Just following up on what was just mentioned, I guess what I don't understand is how you can cut the state constitution out of the equation when it is giving the state legislature the authority to exercise legislative power. It's the state constitution that is telling the legislature when and under what circumstances it can actually act as the legislature. So let me ask it this way. What if what is at issue is not any particular exercise of the state's legislative authority, such as its ability to make time, place, and manner determinations, but whether the entity that is purporting to exercise that power qualifies as this particular state's legislature. So you can imagine that we have two different state entities who claim to be the legislature for the purpose of the Elections Clause, and both of them start acting as such. They set election dates, they have procedures, they issue competing maps and set out different statements about when elections would be held. Would that dispute, the dispute over which entity is really the state's legislature, be decided by federal or state courts, and which law would apply?
It's state law. I think that's a lot of what was happening in Arizona, where the independent commissioning was saying, we're the legislature.
I'm sorry, state substantive constitutional law? We'd look to the state constitution to decide which entity?
Well, it's a procedural issue as to who is the legislature, but
I'm sorry, why is that a procedural issue? My question is, we have these two entities, both of which say we are the legislature, quote unquote, of the state for the purpose of the Elections Clause. And there's a dispute about that. I think you're agreeing with me that that would go to the state Supreme Court. And I'm asking, wouldn't the state Supreme Court look at the state constitution and what it says about who gets to act as the legislature and what authority they have? Wouldn't it be looking at the state constitution to make that determination?
And that's what Arizona
I'm sorry, yes or no? Would it be looking at the state constitution or the federal constitution?
Arizona teaches that the states have the authority, wide latitude, to define state legislature how they want. This is a separate analytical question as just—
Okay, but what I'm trying to understand is why it's a different analytical question.
Well, because
the premise that the state constitution tells us what the legislature is and what the scope of its authority, how it's supposed to act, what it's supposed to do. If that's a state constitutional issue, then what I don't understand is why aren't all of that entity's actions necessarily involving the state constitution? It only gets its authority from that document.
Because Lesser teaches exactly the opposite is true. In Lesser, the state constitution forbade Maryland from ratifying the 19th Amendment, and this court said it didn't apply that state constitution.
No, but that's because that particular issue was delegated to someone else. I'm talking about the authority of the state to act.
Well, Your Honor, under U.S. term limits, the majority of this court said that the power to act in this place, in this sphere, comes from the federal constitution. Now, so the whole premise of this line of inquiry is faulty, but what I'm saying is that our position is whether the term limits majority or dissent was correct, it's a federal function.